Okay, sounds good. We'd like to welcome everybody to another lunchtime training. In finding this speaker, I appreciate Pat for finding him. Uh, Having listened to him for the last couple of minutes and talking with him, I think we're all going to enjoy this presentation. He has a vast amount of experience, and I think he's absolutely perfect for the presentation today. So please take note. Not only has he been a lawyer for a long time, in his experience as a trial lawyer, he worked in litigation, civil, criminal matters, commercial law, bankruptcy law. I also see he's worked on civil forfeitures, which is very interesting to me, although I don't do that much anymore, but I enjoyed it. He's practiced in state court and in federal court. He's been a full-time judge. And I'm sorry about that, but my phone's going off. I apologize. I'll put the ringer off. And please do the same or put yourself on mute. Worked there in Washington District Court of King County, and he was an arbitrator there also in Washington. He's been a hearing examiner and just about everything. He's still a hearing examiner there in the city of Redmond, Washington. That's where my daughter went to college. I look forward to hearing from him. So please take note and welcome Norm Leopold.
Welcome, thank you, Norm. James. And thank you, Pat, for inviting me to speak to your association today. It's certainly an honor to do that. Over my years as a trial attorney and then as a judge, I've had the opportunity to work with many investigators, both in the civil arena and most definitely in the criminal law arena. I've called them as witnesses. I've cross-examined them. I have sat and listened to hundreds, if not thousands, of hours of their testimony. And I'll tell you what, it's all over the map. Everybody does it their own way. I wish they all did it my way, but that just was not in the cards over the years. But I thought when Pat talked to me about doing this, that it would be helpful to not just talk about how to testify. I think that's probably fairly well self-evident, but we'll talk about that briefly. I thought it would be most instructive to also talk about what's going on around you in the court-related proceedings. It's the discovery process. We're going to talk about metadata right out of the gate, objections, hearsay evidence, adverse evidence, cross-examination, like I mentioned a moment ago, all things that either may shape your testimony or influence what you're allowed to testify to, and most definitely will have a bearing on your credibility as a witness. And credibility and impressions as a witness are absolutely everything in this game. So I hope that knowing more about what's happening around you will help you in that regard. For those of you that have had a law enforcement background, which I understand is probably the majority of the association, you may have a ton of experience testifying. So consider this as either a refresher or at least a discussion from my viewpoint about what I think makes for a good witness and, of course, good advocacy at the end of the day. I was mentioning earlier, I mean, I've seen a lot of cops testify. I've seen great cops drop the ball and bad guys walk. I've seen ridiculously incompetent cops carry the day just because they were prepared. So, this is I think it's important to remember the finer points about being a witness so that you don't get scorched. And I'm sure if you've been in law enforcement, you've been scorched a time or two, whether it was justified or not, but scorched by the opposing attorneys. Pat, I'm going to tee up this my slideshow here. Again, we're going to talk about your testimony under oath, but frankly, it is everything around your testimony. And if I were to summarize this seminar, it's pretty simple. It would be prepare, prepare, prepare. I have seen a lot of people mail it in, and it will adversely affect their case and the advocacy of the attorney that hired them in major ways, and oftentimes major bad ways. When you're considering when you're going to probably be a witness, you got to understand that your workup, your investigatory report, however you do it or whenever you do it, may be separated from your court testimony by a year or more. I mean, for a long time, the time to trial in King County and Seattle area was over 4 years. So if you prepare it right in the beginning, when you come back to it and refresh your recollection, look at your notes, if you've done a good job, if you prepared it right in the beginning, it'll be easy to pick up several years down the line. Now, I know this is obvious, and I don't mean to be talking down to you, but the preparation for an investigator starts at the very beginning of the investigative stage. It does not start when you've been talked to about testifying in court. And it doesn't end when you submit your report to the lawyer that hired you. When you're doing your investigative work, I can't stress strongly enough that you document your activity, but don't wait till the end of the week or the end of the month to do it. Do it contemporaneous. I have seen investigator after investigator blow it because they summarize their notes at the end of a particular period rather than making the notes when they're talking to witnesses or looking at scenes or machinery or what have you. Be sure that you proofread your written report if you have one before submitting it to the attorney that hired you. Look at your photos and diagrams and documents, including your witness statements, because when you don't do it, a lot of people get those reports, they're analyzing, and the failure to proofread them could come back and haunt you in a very adverse way. In other words, when you submit your report the first time, bottom line, make it as polished as possible. And there's another point to be made here. When you submit your work, hopefully as polished as possible, from a business development standpoint, you should note that lawyers who try cases love to talk. Frankly, they talk too much, but they talk to each other and they will recommend good investigators. I've seen it over and over and over. I used to get my investigators by calling trial lawyers and say, who you're using and who's good. So if you make a good impression on one, the word may well spread, and that could be good for all of you from a business development standpoint. Now, when I first started practicing, having a computer in your office was a major thing, and not every law firm had them. But obviously, over the last 40 some odd years I've been practicing, things have changed, and virtually everything is done electronically these days. And I'm willing to bet that it's more common than not that you are submitting your investigative materials on electronic form, probably sometimes in both forms, written and electronic. But you need to know that if your submission is electronic, you must clean the metadata out of it. Now, a lot of people, I mean, perhaps you all know what it is, but not everybody does, because we get a lot of metadata associated with discovery materials. Metadata is data about data. It's that simple. You can see it if you know which buttons to push. If you're writing a 3-paragraph Microsoft Word letter, there are scads and scads of metadata associated with that. It's also true for PDFs, word processing, spreadsheets, photographs, calendars, emails. Everything has metadata. And the thing is, if it's accurately analyzed, you can find out material that you didn't intend the other side to have. You could be making notes as you review your materials. I've certainly seen if somebody's making an offer to buy a building for $2 million, they change their mind and they edit their offer letter to 1.5, but they don't scrub the metadata. The receiving party can actually see what their original offer was going to be. And the point to be made is that you could be handing over to the other side very valuable, confidential evidence, including notes you made yourself that were never intended to be seen by anybody else. So I would urge you to be very wary about submitting anything electronically until you have developed a process to scrub the metadata from it. There is it should be mentioned, this has become such a problem that a lot of states, including Washington State, I didn't see it in Idaho, but it may be there. I didn't find it on a quick review, but an attorney who receives documents that has metadata in it now has an affirmative obligation to advise the other side that they sent something they shouldn't have sent. But the bottom line is, be sure you scrub your metadata, because the other side will be in receipt of your investigative materials, and you will be examined on it. And if there's stuff in there that you didn't intend for the other side to see, they're going to get it if you don't scrub your metadata. Now, when might an investigator actually testify? Really, there's only three procedures: the deposition, direct testimony, and cross-examination of your testimony. Now, most private investigations are for matters that don't reach the court system, background checks and stuff like that. However, quite a few might come into court. It's not certain that all matters will ever get to trial. There is some statistic put out every year by the Supreme Court. In federal court, it is estimated that about 1% of all cases actually go to trial. So a very, very small percentage in federal court go to trial. In state court, as I mentioned, the Idaho Supreme Court publishes statistics, and we figure from those statistics about 3% of all cases go to trial in Idaho. In 2022, for example, the Idaho Supreme Court reported that there were 77,402 civil cases. So you multiply that by 3%, that's roughly the number of cases that are filed that will actually see a trial. In the criminal arena, and many of you might be doing investigative work for criminal lawyers, particularly defense lawyers, there were 59,353 criminal cases filed last year. And if you're interested in traffic citations, there were 141,000 traffic citations filed in Idaho last year. Well, the bottom line is, while the vast majority of cases actually never see the courtroom, you know, I wouldn't bet on it. You just have to be ready. Your report should be ready to go, even though the odds are that it won't go to trial. Let's go back now. Depositions. There's a couple things to be said about depositions. We were talking about this before the seminar started. How you present yourself in a deposition or court hearing, any one of these three elements is very, very important. I bring it up now before we talk about the nuts and bolts of this thing, because if you're in front of a judge or juror, or even the opposing attorney or the attorney that hired you in a deposition, they're going to be weighing and balancing how you're comporting yourself, how you look. Your appearance is very important, and how you comport yourself. You're being assessed as a witness. And I've had great investigators, and their deposition is taken. And boy, I think after the deposition, I wondered, gee, maybe can I try my case without that witness? So all these things from the word go are going to impact how people perceive you. We use, a lot of this isn't so much legal as common sense, but you need to be prepared to make a positive impression by how you look and how you comport yourself. You want to be considered as credible throughout. Now, I say this fondly, but it's a bit rude, but judges and jurors are like dogs. They can smell somebody who's not confident or not credible, and that a lot of that is how you look and how your body language is coming across, and how you comport yourself. So you need to take care in how you looked in your act, starting with a deposition. When I say judges and juries are like dogs, that's a compliment. That's their job, is to smell your credibility, your truthfulness. You know, what kind of a witness are you? Were you a great one, a mediocre one, or one that they're going to forget when they go back? The jury's going to forget when they go back and deliberate. Now, when you appear in front of a deposition, again, keep in mind, like I said a second ago, impressions are largely formed by nonverbal communication, and dressing poorly is going to create a bad impression in the eyes of the judge or the jury. Don't wear your jogging suit to court or some obscene t-shirt you picked up at Sturgis last year. You know, if you're not a suit person or a skirt woman, don't wear stuff just for the heck of it. You look uncomfortable, but do wear something that is not going to make you squirm and, you know, is going to be a statement about your competence as an investigator, your credibility. Dress nicely, but do it in a manner that you're not going to be uncomfortable. It isn't necessary to have a tie. A lot of witnesses don't have ties. That never bothered me. But when they come in a tank top or shorts and flip-flops, it's not right. Sometimes people's liberty is at stake in a courtroom. Oftentimes financial penalties can be at stake. It's not the place to dress casually. It just isn't. And with regard to your ties or pins or brooches, no political sloganeering, no messaging, no symbolic stuff on your apparel. You don't know what politics the judge has or the jury has, and you can make a bad impression by wearing something that means something positive to you, but may mean something negative to the trier of fact. So don't do it. Your voice inflection, speak steadily. You're reporting on your activities and what you found. Your attitude, you're in court as a professional, one of the many professionals that make up any given case. This is what you do for a living, and you're here to report on the fruits of your labors, what you covered, what you uncovered or discerned, what you saw, what you heard, witnesses you spoke to. Here is what I found in my investigation. There's no need to be excited about it. You're trying to be helpful, hopefully more helpful to the party that hired you than to the other party, but you're trying to be helpful. Your demeanor, you know, you're not a robot, you're a person, and maybe you've got a lot of experience in this, but your testimony certainly is not the time to be angry, depressed, or excited. Maybe you want to take the wrongdoer to the mat. I get that. Maybe you're mad at how you've been treated throughout the proceedings by the other attorney or even by the judge. Don't get excited or angry. You be relaxed. Don't look like you're unhappy to be there. I've seen many people, many witnesses, you know, they don't want to be in court, that they look unhappy, and that does negatively affect on their credibility. Now, what you're doing in court is simply a part of your professional life. It's another day at your office. Eye contact. This is one of the great, I can't tell you how many people won't look you in the eye. And you need to look your examiner in the eye. More than one juror I've spoken to after a court has picked up on witnesses who don't do that. And I must tell you, if nothing else, if you don't look somebody in the eye, your credibility is going to go in the toilet very, very quickly. It happens a lot, and I'm always beside myself when I see it because it's simple. Just look them in the eye. When you don't do it, it may look to the judge or jury that you have no self-confidence, that there's a cover-up, that the truth isn't being told, stuff is being hidden, or even worse, that you're bored with your own case. So it does make a difference. Manners, I can't tell you, you know, the courtroom is not the place to have bad manners, and it happens every day. Politeness counts. It just plain counts. I'm polite to the people I dislike, and it's just the way it is. It creates a sense of legitimacy for the court, and you just need to remain polite, and be polite even when the opposing party's attorney is scorching you. The case is what it is. Just be polite. And probably the most important bullet point on this list on the slide is remain confident. Do not prevaricate when you're testifying. Answers such as, I don't know, maybe, I think, Probably. Suggests that you're not prepared or you're not confident in the matters in which you're testifying. You're a professional. Come to court, remain confident. Do not prevaricate. This isn't you're not a TV character like Columbo or Nancy Drew. You're confident in what you do. And you got to remember that you may be facing jurors who've never seen or heard from a private investigator before. So your confidence is going to tell them, well, here's somebody who knows what they're doing. And they did their own investigation. I need to listen to what they're saying. So again, don't prevaricate, be confident when you're in court. Now that's what you need to do. Here's what you shouldn't do. And now again, this is obvious, but I sat there day after day and I would just bite the insides of my cheek, watching people react adversely and in many cases damage their case. This goes without saying, but you should never lose your temper in court. Don't get irritated. Don't get combative. You're going to be baited. We were talking about cross-examination right before the seminar started. You're going to be baited. That's what lawyers do. Sometimes they do it artfully. Sometimes it's inartfully. Sometimes it's just plain rude. But don't lose your temper. Lawyers in cross-examination might even accuse you of nefarious conduct. Don't lose your temper. Stay calm, objective, confident in the work you've done in conducting your investigation. That's your job. Let the other people do their job. They might look like fools for trying to get away with stuff like that. If you don't lose your temper, stay with it. The second item is never get smart with the attorneys. Now, attorneys always think they're the smartest in the room. Maybe it's the truth. Probably it's not. But, don't get smart with them. They're trying to do their job. Again, sometimes it's artful, sometimes it's inartful. But don't get smart with them. Don't try to outfox them. I've had jurors when I was a trial lawyer, juries award me double what I've asked because the witness tried to outfox me, and it just doesn't work. Roll with the punches. Don't get shaken up by questions from the opposing attorney that may inferentially suggest that you're being dishonest or careless or even have a lack of good character. Just roll with it. Now, be careful about what you bring into court. If you're referring to notes when you testify, and again, there might be a year or more between your investigative work and your trial or deposition testimony. When you're referring to notes in court anyway, those notes can be asked to be reviewed by the examining attorney. And if you bring an original file into court that has stuff that you wanted to keep confidential, and the attorney asks to see the file, you're going to be giving up stuff that you hadn't intended to, much like metadata. So be careful about what you bring into court. I was going to be cautious about war stories, but I was doing a collection case, simple enough, but the defendant said they had no money. And I saw this wallet bulge in the back of their pants. I said to the judge, Your Honor, there's a wallet in that guy's pants, in the defendant's pants. I want to see what's in it. So I got a turnover order right on the spot. The guy had to turn over his wallet to the judge. He opened it up. There were several $1,000s of $100 bills in that wallet. And I got a second turnover to have that money turned over to my client in partial satisfaction of the debt. So that's illustrative by a simple story. Be careful what you bring into court. Now, not that anybody in this association would ever be involved in illegal or unethical activities, but it can happen. Trespassing, illegal surveillance, using pretextual reasons to be somewhere where you shouldn't be, using other identities or otherwise to solicit information. Look at if you've been walking around the edges of ethical conduct, okay, there might be arguments on both sides for whether it is or whether it isn't, but do have a discussion about it with the lawyer that has hired you. Because the one thing you don't want to have happen is to have that thrown back at you in front of a judge or a jury in a cross-examination. It happens frequently. You would think it wouldn't, but it does. And your job is to avoid letting it happen to you. And you do that by prepare, and certainly discuss it with the attorney that is hiring you. And the same thing is true for soft spots in your testimony. Sometimes there's good things that you could testify to, very solid evidence. Sometimes there's shakier evidence, or maybe even circumstantial evidence. But work it through with if you have this opportunity, work it through with the attorney that has hired you. That can be handled very artfully, even if it's kind of bad. But if you hide it, it's going to come back bad for sure, and it's going to leave a bad impression on the jury. Never, ever exaggerate. Again, it should be common sense, but sometimes people get full of themselves and they exaggerate, and that doesn't work. Also, don't try to shoehorn your testimony into an answer that you expect will be beneficial to the ultimate client, or what you think your attorney who's hired you wants to hear. Don't make assumptions. You're going to report the facts that you investigated. Now, here's something, well, go along the same lines. Don't speculate. Never, ever speculate. That speculation will come back to haunt you in so many ways. Your head will spin. Don't speculate. The last one on this list, and I see this over and over, don't organize your testimony from the witness stand. I mean, if you're doing it on my time, I'm going to be really mad. But if you're doing it on the jury's time, you got 12 people are going to be mad, and that's going to create an adverse feeling on behalf of the jurors about you and your testimony. You're a collector of facts, witness interviews, online research, phone calls, document review. If your investigation is multifaceted, have it organized. Don't do it from the witness stand, and it'll look better as well. And again, from a business development standpoint, attorneys will talk. I've heard it over and over in chit chat. The guy was prepared. The gal really knew what she was doing. It was a great investigation. So organize before you get there. Don't organize while you're there. If you do it on my time, I usually got mad because it's a waste of court time. And it's not just me sitting there. There are 30, 40 people involved in bringing a case into a courtroom, and everybody's time gets wasted. So prepare. That's the first slide. And organize. That's this slide. Now, let's talk about testimony under oath. The deposition is the first one. This is it's a very common thing in civil litigation, and it can even be done in criminal litigation. I've certainly done it as a criminal defense attorney. But a deposition is usually just a fact-finding procedure, and it's considered a very integral part of the discovery process. Discovery process means exactly what you think it means. It is how the attorneys discover facts, evidence, and witnesses that the other side is going to use to support their case or defend against your case. A deposition allows the other side to question you under oath in an informal setting, such as an office conference room or even on a video chat, about what you did and what you found. The testimony is taken in front of a court reporter under oath, and that transcription can be requested from the court reporter. It does not happen automatically. You do have to order it. Sometimes attorneys don't order the transcript because it's very expensive, $5, $6 a page, and they choose to save costs. But if they do order the deposition transcript, this is a verbatim report of what questions you were asked and your answers at deposition. The point to be made is that transcript can then be used for trial preparation by the other side and your side as well. And it can be used in trial for a variety of purposes, not just to organize a case. It can be used to impeach your testimony if for some reason your court testimony doesn't match your deposition testimony, or it was damaging at some level, it will come back to you at trial. So the deposition has great value. And it might also be that the other side has an investigator who found something different. And so, you know, the depositions are going to be revealing what each side has to offer on any given issue. And they can be used. They can be used to impeach you. If your deposition transcript has been ordered, I strongly urge you to read it before your testimony. That will refresh your recollection. If you don't read it and you're relying on your memory, you may be very unhappy with the results. It's also interesting to note that in deposition, there is no judge. And this is where it can get wild and sometimes unruly. Not every time, but it does happen. There is no judge. So what happens is that if there's objectionable testimony in a deposition, the rules require it to be actually given and sorted out later. It is also the case that you cannot ask for a recess and go talk to the lawyer that hired you in the hallway to figure out how to answer any given question. You are not permitted to do that. There is no judge there, so you're not going to get rulings as you go. And you may have to cough up answers that you didn't want to, but hopefully the attorneys will sort that out down the road. I have been involved in many depositions where the attorneys, even though the rules say you can't refuse to answer a question, they do refuse to answer a question. Well, it can create a very ugly situation, but sometimes judges are on call by phone, or you take a recess in the deposition or continue it and sort of keep this portion of it separate. And then you make a motion to have the judge rule on whatever the legal issue is. But in the deposition itself, there is no judge, and it can get out of hand. There are also other methods of discovery I thought it'd be worth talking about just a bit, in addition to your investigation, which might provide facts and witnesses and diagrams and photos and that sort of thing. It is typically the case that attorneys oftentimes send out interrogatories to the other parties first. Interrogatories are written questions addressed to the other party that ask for answers to be given under oath. And they also can be used to stimulate further investigations, or they can be used to impeach you in court. There are requests for production or inspection of documents and items. So you can see what might be the focus of a case. A subpoena ducis tecum is a document subpoena. We can get documents. Subpoena ad testificanum, of course, is to compel a witness to appear. The court rules do provide for physical and mental examinations of other parties. The court can, or attorneys oftentimes send out documents asking the other side to either admit or deny certain propositions. And if you deny it and it turns out they prove it, you can end up being responsible for attorney's fees. It's kind of complicated, but you know, if you admit and deny correctly, you can truncate a case down to something. It may take a couple hours rather than a couple days or a couple weeks. Those are facts that don't have to be proven by testimony. Now, this middle one right here, the parties have an affirmative duty to supplement discovery responses. If you presented an investigative report and now you're a year, 2 years down the road, and you've done some further investigation, maybe talk to some witnesses that you didn't know about before, go out and take a look at the scene at a different time of year. Maybe you've got some testing back from a lab that stimulates more investigation, and it changes your report, and you hand it off, your amendment to the report or addition to the report to the attorney. That attorney has an affirmative duty to supplement the original response. So if you've got new stuff, you've got to turn it over to whoever hired you, and that attorney has to present it to the other side. So there's an affirmative duty to supplement. What happens if you don't? A trial judge may prevent that testimony on the supplemental portion from being heard in trial. And that could be a very important part of your case. So if you've got new information that didn't appear in your report, turn it over, but do expect the attorney to submit it to the other side. Now, what happens if you don't cooperate in discovery? And by the way, there's many more items that you can use in pretrial discovery work, but those are the principal ones. Now, if you fail to cooperate in discovery, the parties can certainly obtain an order compelling discovery. That is now a court order commanding you to turn over something or present something you've got in your possession that may be of evidentiary value. If you fail to abide by a court order compelling discovery, it can be treated as a contempt. I've never seen criminal penalties associated with a civil failure to comply with a discovery order, but I've seen thousands of dollars in fines and court sanctions. It can result in a stay of proceedings, a dismissal. It can result in the striking of pleadings, attorney's fees and costs. So the bottom line is, know that your work is going to be seen by the other side, and it's supposed to be seen by the other side. The last word on depositions is that, as I said before, the pretrial deposition is a fact-finding mission. It is highly unlikely that you're going to be cross-examined in a deposition, or at least at any intensive level whatsoever. Attorneys are going to be looking at you for weaknesses, holes in the case, inconsistencies, how you hold up under intense questioning. They're going to be sizing you up. It will not be the cross-examination that you can expect to see in trial. They're just sizing you up. So be prepared for that. A word also on depositions. They can be taken to preserve testimony. As I said, if your investigative work is separated by court activity by a year or more, it may be that you're unable to participate. Maybe you have conflicts, maybe you're ill, you might not be able to make it to trial. Sometimes depositions are taken to preserve testimony so that we have it in the case where the witness becomes unavailable down the road. So it's not always by a deposition noted up by an adverse party. It could be noted up by the attorney that you're working for simply to preserve testimony. This is more the exception of the rule, but I've done it many times, and particularly if you've got elderly witnesses, you can't bank on the fact that they're going to be there when you need them to. So you take their deposition testimony to preserve the testimony, and it can then be, if it's handled correctly, can be used in trial as the trial testimony. Now, most of the depositions are basically just who, what, where, why, and how, as far as you're concerned. They may be asked of you in a chronological fashion. They may be not asked in that way. I myself oftentimes would not allow my questions to be offered up in sort of a chronological recitation of what you did and when you did it. I personally preferred to bounce around from topic to topic, and it kept my witnesses off guard. Even if prepared, kind of bouncing around can create chaos in their mind, keep a witness on nerve, and it tends to destroy some of the pre-deposition preparation. And you get some truth sometimes that you hadn't anticipated. So again, just be prepared to do your job and not try to outfox the other attorney. If you need to think about the question, fine. As I said, you can't go out in the hallway and ask the attorney that hired you, what should you do? Just take each question, answer it carefully. Don't anticipate the next question or where you think the attorney's going to go, because you have no idea. In truth, most attorneys are very poor at taking depositions, but you can't bank on that, so don't. Let the attorneys shoot themselves in the foot. Don't do it for them. Just understand that these things, again, without a judge, can go lots of different ways, but just do your job competently and everything will fall into place. Now, the next time you testify under oath may well be trial. Here I got opinion testimony. We'll talk about that first. It is not the case that a witness can simply offer up an opinion. And while you may have a fair modicum of experience as an investigator or even a prior career in law enforcement or military, you can't just offer your an opinion. Now, in Idaho, a judge can hear foundation testimony on whether or not the type of education, training, experience you have will allow you to offer an opinion. And this is Rule 701. These are the Idaho Rules of Evidence. They control a lot of what I'm talking about today. It's IRE, they're public, you can find them on the web. The Idaho Rules of Evidence 701. You are considered at this point a lay witness, and if you're not testifying as an expert, which we'll talk about in a second, your testimony in the form of opinion or inference is limited. And here it is, unless it's rationally based on your perception, helpful to clearly understanding the witness's testimony or to determining a fact in issue. This is up to the judge. It is a discretionary decision. If you start testifying in an opinion fashion, you're going to get an objection from the other side, and a judge is going to have to determine whether or not your testimony falls within the four corners of Rule 701 and whether or not your opinion can be allowed. Now, this goes hand in hand with expert witness. I understood somebody in the association was testifying as an expert witness in a criminal trial or something like that just this last week. And that's certainly possible. If you have a law enforcement background, you may well have the type of knowledge, skill, experience, and training to be considered an expert. But it just doesn't come into being by handing a resume around the courtroom. A judge actually has to determine whether or not you do have that knowledge, skill, experience, training, or education that allows you to testify as an expert. Oftentimes, this is done outside the purview of the jury. It's sometimes done in a pretrial motion where people are asked to agree that you're an expert or hear testimony on a court hearing not associated with the trial, maybe months before the trial even. But you just don't become an expert by saying you're one. Now, those of you who have law enforcement backgrounds, you could have accident reconstruction training, ballistics training, blood splatter training, toxicology training, and you may be able to have the attorney that hired you, you may be able to have a judge determine that you can in fact testify as an expert, and as an expert, you can therefore testify to your opinion. And without a judge's ruling on whether or not you're an expert, you will not be able to give opinion testimony. There are a lot of fights that occur in the courtroom about experts and opinion testimony, but ultimately it's a discretionary ruling by the judge. I was not particularly soft or hard on those things. Sometimes it was my opinion. Well, if there is some training and experience and knowledge, we'll let the jury determine if it's a jury case. Let the jury determine the credibility of your testimony being given as a so-called expert. That is different than an expert private investigator. We're talking about, again, some people can measure speed of a vehicle by looking at skid marks. Well, you've got to have skill and training to be able to do that. The judge has to determine you have that. You're declared an expert. You'll be able to give your opinion on what you thought the measurements showed in terms of speed. Now, let's see what we go here. I wanted to talk about modifying your statements too. It is no doubt also the case that you may want to modify your report. It happens all the time. Work with the attorney that hired you. There's nothing wrong with modifying it after you first did it. That's expected. But be sure that you work with the attorney so they can bring it up and present to the judge or jury in a good fashion. I want to talk briefly about hearsay testimony. Hearsay in general is not admissible except as permitted by the rules. That's Idaho Rule of Evidence 802. I can also tell you that most judges and most lawyers have no idea what hearsay is. Hearsay is a statement that the declarant makes out of court testifying about what somebody else says in an effort to prove the truth of the matter asserted in the statement. Now, it sounds simple, but it's not. It's terribly complicated. That's in the Evidence Rule 801, 801C 1 and 2. There are 23 recognized exceptions to the hearsay rule, and there are some exceptions to the definition of what hearsay is. There are also rules about hearsay within hearsay. So when you're investigating and you're talking to somebody who says, oh yeah, no, John Doe told me they had the gun underneath the bed. Well, that's hearsay. Now, if it's not a gun case, if it's a fishing case, then it's not being offered to prove the truth of the matter asserted in the statement because it means nothing. So a judge is going to be determining what hearsay is. Luckily, it's not your responsibility. Your attorney that hired you should be looking at your report going, you know, we've got a hearsay issue here. The attorney needs to be prepared and ready to argue with the judge about what should be admissible and what shouldn't be admissible. We could spend all day on hearsay, but it's up to the attorneys. So I think we should move on in the interest of time. Objections made to your testimony. If you've testified at all, no doubt you've heard objections made to something you're about to say or the question that was asked of you. This again is more up to dealing with it is up to the attorneys, but they could cut out very important parts of your investigation that you had intended to testify to. These things should be worked out ahead of the trial so they don't come as a surprise to you. But the reasons for objection include inadmissible evidence, speculative testimony, opinion, hearsay that we talked about, failure to lay proper foundations. You can't just say, you know, the photograph, this is a photograph. It's got to be, well, this is a photograph of the scene of the accident. It was taken on such and such a date and time. I took it. I recognize this as the intersection where the incident occurred, according to the police report. You got to lay foundation for the admission of testimony. It just doesn't come in blindly. Attorneys leading the witness during direct testimony. If you ask a question of a witness that suggests an answer, you'll draw an objection for leading. These are basic questions. Where were you? What were you doing? What did you find? What did you see? What did you ask? Asked and answered. Sometimes attorneys ask witnesses questions over and over. Evidence is admissible if it's relevant. And if you're talking about evidence that's not relevant, it is objectionable. Argumentative questions, non-responsive questions. Sometimes objections are just made to unnerve the witness, or even more, it's to get into the head of the other attorney. So objections are made for a lot of reasons. So what do? Well, you may get a favorable ruling and you may not. You can't bet on it. Judges come to the party with all kinds of experience, and you don't one judge to the next. You may not get the same rulings. What you shouldn't do is don't utter any expletives, words of dismay, or anything else. No eye rolling. Just take what is given to you by the judge and live with it. Remember, the judge and the jury are watching you. The evidentiary rules are complicated. They're sometimes a mystery, but you're the witness and you just have to play the hand you're dealt. You may not know the reason for the ruling, as it may not be spelled out by the judge. The lawyers could be talking in acronyms or some kind of shorthand. They could be referring to the rule by numbers. You may not know what's happening. There may be pretrial rulings that you may not be familiar with. So don't slip into a rabbit hole because you're mad or your testimony gets eviscerated. Just roll with the punches. The judge and the jury, frankly, are going to be looking at you for a reaction. So just don't get unnerved. It's just another day in your professional life. Objections happen. Sometimes they're sustained. Sometimes they're overruled. Just roll with it. Don't damage your credibility in the eyes of the jury. Look like a pro. And by the way, if you don't understand the scope of an evidentiary ruling, you are absolutely free to turn to the judge and ask the judge, Your Honor, I'm not sure I understand the question. And the judge will ask the attorney to rephrase it. You can even ask the attorney straight away, I'm sorry, sir, I don't understand what you're asking me. But just don't lose your professional demeanor. Don't inflect your question to the court with any animus. Be the pro, stay a pro. If attorneys are objecting just to disrupt your rhythm, that's the way it goes. Myself, I'd only like to object when I was trying cases. I only like to object to big ball issues. I let the small ball issues go because when an attorney objects, the jury and the judge, it's just the way it goes. The juries and the judge will think that the opposing party is trying to hide something. But that's, again, stay a pro and you'll be just fine. We didn't talk a whole lot about direct testimony, but obviously, unlike a deposition, it is going to be with a judge in attendance. We've talked about objections. The attorney that hired you is going to go through your investigative process and your findings, perhaps being qualified as an expert, perhaps being qualified as a non-expert, but be qualified to give an opinion under those rules that we looked at a moment ago. It is also true that the other side can call you as one of their witnesses. And I've done this myself. It tends to confuse the witness, but there are reasons to do it. And sometimes if you call an adverse party or a witness who was hired by the other side, you can have the judge determine that they are in fact an adverse witness. And even though it's direct testimony, you are permitted to ask leading questions of the witness. But nonetheless, in your direct testimony, just be a pro, roll with the punches, don't get unnerved by anything that happens. Now we hit cross-examination. This is where you can get beat up, right? Let's just say that your direct testimony went well. It was clear, it was organized, it was prepared. You aced it. It was a hole-in-one. It was a three-point hoop shot. And you thought maybe I could be a preacher on Sundays. This went so well. Well, you had to know that things were going too well because now it's cross-examination time. And this is a very difficult thing for most attorneys. Very few of them are good at it. You see all kinds of approaches to cross-examination, but when cross-examination is good, it is surgery with a very, very sharp scalpel. I was saying earlier, this is one of the things when I was a trial lawyer I lived for. I prepared hours and hours and hours for it, and it makes a difference in cases. In general, cross-examination is the testimony of a witness who's already been questioned by the other side. And now it is your turn as an attorney to ask that witness questions. The questions can be leading, and they should be. A leading question is one that suggests the answer within the question. And if done correctly, basically gives the witness, such as yourself, an opportunity to basically say yes or no, true or false. And so the best lawyers in the business understand that cross-examination is a battle for impression. It is not a battle of logic. They're trying to make an impression in the eyes of the jury or the judge if there's no jury. And it is used in the main to attack your credibility by poking holes in your direct testimony and giving the impression to the judge or jury that it was either an insufficient investigation or the investigation was full of holes or what have you. It is used to create doubt. In a criminal case, it is used to create reasonable doubt. In a civil case, it is used to defeat a preponderance of evidence. You know, you might have 35 years of experience in law enforcement as an investigator or as a PI, but make a mistake in your direct testimony or use unwarranted assumptions or speculations. When it comes to cross-examination, you're going to be shredded, absolutely shredded. So understand before you get in there that the other side will have seen your reports, your deposition may have been taken. They are ready for you. They may have their own investigative report. And if your testimony differs from your deposition or has holes in it, it's going to come back to you. Now, for those of you in law enforcement, I've said this many times in different ways in other contexts. I've had in 31 years as a judge and almost 45 years as a trial lawyer, I've read tens of thousands of police reports. Now, this isn't to say I'm good, but I've never read one that didn't have something I could use to cross-examine. So, you know, you do the best you can. Make your reports as polished and as competent as you can. But these things, there's stuff to work with in everyone, and I've never found one that I couldn't work with. Cross-examination could challenge your identification of a witness. It could challenge, you know, the angles in which you took photos of the scene of an incident or an accident. It could be a challenge to you to recall elements of your investigation. It could be a challenge to your truthfulness. And it's all in an attempt to impeach you as a witness. So bad attorneys, on the other hand, who are cross-examining you, may give you an opportunity to restate your testimony. I can't tell you how many hundreds of hours I've sat listening to bad cross-examination where they're giving the other side a second bite of the apple by letting the witness restate his or her testimony. So you get what you get with a lawyer. You won't know till you get there, but just stay professional, prepare, read your reports before you come into court, and do the best you can. Just don't get aggravated by what happens to you. The lawyer's most powerful weapon in cross-examination is the ability to put words in your mouth, and that is in fact allowed by the rules of evidence. You're going to end up telling a story by words used by the opposing attorney. You're not going to be permitted to explain unless the other attorney, the one that hired you on redirect, asks you to do so. Good attorneys will do that. You never know what you're going to get with attorneys in cross-examination, but it is one of the most critical parts of your trial. There are lots of variables in it, but again, it is usually done by leading questions, and good examiners will get in and get out very quickly. I hope that this has been helpful in understanding that there's a lot that happens around your basic testimony. You do it well, and you're going to be considered a very valuable part of the team necessary to prove and prevail on difficult cases, and you will be in demand around that legal community. Testifying can be fun, it can be irritating, it can be boring, it can waste scads of time that you could be placed elsewhere. It can be fun, it can be irritating, it can be anger-provoking, but it is what you do if you're in this business. And so if you do it well, you're going to get more business, and you're going to become a good part of the advocacy necessary to win cases. So I hope that was helpful. And Pat, if there's time, I'm very happy to take, James, happy to take questions.
James, you're muted.
Okay, there, I believe I'm unmuted. We do have some questions. First of all, thank you very much. That was very, it was a great presentation. I think you covered many different questions that our investigators had. We have a question from the investigators asking about if you can explain the appeals aspect of the objections, clarify purpose and reasoning. And I was typing up to better understand the question. If he's talking about when somebody is testifying and there is an objection, I don't know if it's whether he should, finish the sentence or if he should wait for a court's ruling for the judge to say either overruled or sustained, or if he's talking about why they object as far as, to make a record for the court for possible error or a point they want to argue on appeal. So,
James, your question is compounded. It's objectionable. So I sustain the objection. It's a great question. And I'm sorry I didn't mention this earlier. When the objection is made, you should stop talking, because there's nothing worse than a witness who keeps on talking and may inadvertently blurt out evidence that shouldn't be heard. But the other part of your question was the reason for the question, reason for the objection. Again, it could be to make certain that bad evidence doesn't get admitted. It could be to keep the attorney on their toes, to unnerve them. It could be done for a lot of reasons. But from an appellate standpoint, if you do not object to a piece of testimony, you waive the objection for purposes of appeal. You cannot go into the appellate court and say, I hated this guy's hearsay testimony. The appellate court's going to go through the transcript and say, well, you failed to object. Therefore, you have waived that as an issue on objection. So sometimes we make objections knowing that the judge is going to overrule them for whatever reason, but we're doing it to preserve the record. It also gives the judge a chance to make a record about why an objection is either sustained or overruled. So the objections are really to make certain the record is complete for purposes of appeal. Otherwise, you waive it. It's that simple.
Does that answer your question? Yes. Okay. Very good. Thank you for
got lucky on that one.
Yeah, I was typing up and I said, I'm just going to let him, because I'll take up too much time talking. Okay. How about, let me see. The questions that I would have would be, I guess, a brief overview on maybe Daubert and Fry, just so people know what's the difference and what they're talking about.
Yeah, that you're talking about scientific evidence?
Yes, sir. As for expert testimony.
Yeah, I'm not prepared to do that today. That's very complicated. But I mean, Fry comes up all the time. And, there's a lot of science out there, but it's not all accepted. And even the breathalyzer, even today, and the breathalyzer has been in use in virtually every community for, 50, 60 years now. Even the science behind that is oftentimes challenged on a Fry basis.
Extrapolation.
And DNA evidence, of course, is used a lot now, but there's lots of different science out there. And unless the science is, I guess the simple way of saying it is an established science, the judge may not permit the testimony to be offered. And we've seen researchers and doctors come in talking about experimental stuff where there's a genuine dispute about whether it is acceptable therapy or treatment. So Fry is a complicated, that's worth a 2-hour seminar.
Right. Well, just I guess my main thing there is if you testify as an expert, be aware of Daubert and those decisions.
Well, I've seen many experts testify, and then the attorney has a treatise written by, like the Harvard Medical School staff debunking what the witness has just testified. That cross-examination can be brutal. I've seen expert witness having not read the latest science on whatever it is they're working in. It is sometimes astounding that a well-regarded expert doesn't know what's happening in their field.
And the rules that you cited, were they in Washington State Court, or were they based on Idaho statutes?
No, the rules that I referred to are the Idaho Rules of Evidence. They are specific to Idaho. They are not Washington rules. The Idaho rules and the Washington rules, for that matter, are actually based on the federal rules of evidence, but they are not word for word the same as the federal rules of evidence. But in court proceedings, we have, and these aren't statutes, these are court rules affirmed by the Supreme Court. We have the Idaho Rules of Evidence, which I've talked about. We have the Idaho Rules of Civil Procedure, which covers things like depositions. It covers witness, how you call witnesses and when. The Idaho Rules of Criminal Procedure. So what we do is heavily regulated by rules. As a courtroom, as a trial judge, the rules were very important to me because it was the only thing that the parties had in common were the rules. And I frankly, I made the parties adhere to the rules. So when you start departing from the rules, then it does get chaotic. Now in Idaho, for years, this has not been a very wealthy state. It is certainly not a very populous state. There's a lot of discretion that the judges have because there are no rules or case law or determinative law. In a lesser wealthy state, not everybody can afford to take appeals, and we don't have, there's certain areas of law we don't have good precedent. So trial judges can be supremely powerful in Idaho, and most attorneys who try cases here know that. And they will be prepared with a hip pocket brief or a memorandum, something to convince a judge where there is no precedent that they should be ruling in a particular way. It's a very interesting state. It's actually fun. It's kind of like the Wild West.
I think it's especially interesting because in dealing with the Ninth Circuit of Appeals, I see some interesting things come out of there. So any comment on the Ninth Circuit?
No, I would offend most of your membership, I think.
That's why I asked. Okay. Very good.
Maybe I'd make them all friends. I don't know. But the Ninth Circuit is a very liberal circuit. And there are 11 different circuits. They each have their own precedents, and they may all be different. On the same issue, they may be wildly different. And if the Supreme Court accepts a case for review, that would be the time where the difference in circuit court opinions would be harmonized.
Right, very good. Any other questions? Anybody online have any questions? Speak now or forever hold your peace. I hear some crickets, but we'll wait a couple more minutes or a couple seconds. I'd like to thank you so much, Norm. I'd love to, if you're ever in Boise, I'd love to buy you lunch and sit down and listen to some of your stories. I worked in a prosecutor's office for 8 years as a chief criminal investigator, and we dealt with seizures and all sorts of things. And I'd love to talk with you and listen to some of your stories. If we don't have any other questions, anybody else have any questions? You can unmute yourself if you want to ask the man himself.
I just want to thank you, Norm, for coming by. That does mean a lot to our association, and you know, I'm sure I speak for everybody here. Having your view on things and having you come in from a different perspective from an investigator helps out significantly. You know, and it gave me better understanding on a few things from a case that I went in for a witness on, you know, as you heard us talking about at the beginning here. But no, definitely thank you for coming on board though.
Thank you, Matthew.
And I have a question. Yeah, thank you so much for taking the time to. I learned a lot. I took like 4 pages of notes. My hand's tired. The hearsay, you said you could spend hours and hours on hearsay. I mean, would you be willing to do that? Because I run into that a lot with my clients. They tell me they have proof, they have this, they have that. And it's somebody saying something to somebody else. It's, when does hearsay become evidence? Is there such thing as hearsay evidence? You know, all that stuff. Just, I would love to get some
If-
more information on that.
If you got a few minutes, I actually have on another screen the exception to the hearsay rule teed up on a slide.
Bring
Okay.
it.
Okay,
Please.
would take a couple hours to go through this, but this will give you an idea of the many exceptions to hearsay testimony. Let me see if I can get this for you.
Norm, maybe this will be a good next webinar.
Yeah,
Yeah.
Whoops.
Oops.
Yeah, I think that, man, when you said that, I was like, holy crap, it's a lot more complicated than I thought.
Maybe I don't have this up here yet.
Oh, you have to do a class.
It's the, hang on for just a second. I think I took that off earlier. Hang on. Okay, hang on.
And
Here
for
we go.
those, just so everyone knows, this webinar will be on our website as soon as it can get posted. And
Mhm.
it will also be in the quarterly newsletter.
Nice.
Okay, you can see the screen. This is the syllabus here, Idaho Rules of Evidence I referred to. The hearsay rule is contained in rules 801 through 806. These are available, by the way, easily available online. Google it. But if you take the rule 803 here, we'll make it a little bit bigger. You can see this goes on and on and on and on and on. These are all exceptions to the hearsay rule. For example, present sense impression. If you heard somebody explaining an event while they were emotionally excited, even though what you're hearing is testimony, it's considered a present sense impression and therefore admissible in court. Now, a judge might have to hear that outside of the presence of a jury to determine whether it becomes a present sense impression or an excited utterance. And there's just tons of, yeah, we could do a hearsay thing. I would have to learn about the hearsay rule myself at that point, but yeah.
All right. Well,
Well,
that's a good cliffhanger.
Yeah. Sorry, James. Because I did a case one time where a guy was getting accused of attempted murder. He shot a guy. The police said they had a witness saying that she heard the defendant say that he tried to kill him or whatever. Come to find out, she had heard it from somebody else who said they heard it from him. And he got off on, I mean, it was a big reason why he got off on self-defense, but I wasn't there. I didn't get called in, and I just did not understand how important that was. I just, you know what I mean? The attorney didn't really explain it to me. That's just what he told me. So
that is actually hearsay within hearsay, and that's rule 804. I mean, the Supreme Court has tried to make this easy. It's an inordinately complicated set of rules.
okay.
But the bottom line on hearsay, the absolute bottom line is, in general, hearsay is unreliable.
Okay.
And that's why these rules exist. If somebody says something against their criminal interests, there is an exception for that too.
Jeez.
But what you just recited to me is hearsay within hearsay.
Oh,
And that's
okay.
that's unreliable.
Okay. Yeah, so that's the type of stuff I'd like to know. A lot of that stuff when dealing with my clients and things. 'Cause-
Number 22, well, I guess that's not the one, but yeah, judgment of a previous conviction. I guess that would be a record, but there are plenty of exceptions, but a statement against criminal interest is one of them.
Very good. Okay, Norm, thank you on behalf of the board, on behalf of our membership. We'd like to thank you for just a great, awesome presentation. We do want to welcome you back at your earliest convenience. We have lots of topics for you, but hearsay is a good one. So thank you. I also like to mention to whoever's watching that we can also post some good metadata removers that are specifically for Android or for iPhone or for your computer. And of course, there is some very good freeware aside from professional versions, which cost only about $60. So Thanks again, Norm. We appreciate you, and we look forward to talking and meeting with you in the future.
Thank you, James. Thank you, Pat.
Thank you.
Thank you, everybody. I'm going to sign off. Take care.
Bye-bye.